All right, everybody. How are you doing? My name is Attorney Anthony Reeves, and I want to take some time to talk to you about what we call the trial work period as it relates to the Social Security Administration. I want to thank one of the commenters to one of my posts who asked me to take some time to talk about the trial work period. So, excuse me if you see me looking down or looking away. Primarily is because I'm going to be highlighting my notes. So if you see me putting lights and you see them coming out of my glasses, it's because I'm trying to read at the same time. Now, first, let me kind of set the stage. You've applied for disability benefits. You've bust your butt to get them. And now, after a couple of years of going through the system, you find yourself in a position where you're wanting to see if you can go back to work. But you're scared. Why? Because you took 2 and 3 years to get these benefits and you don't want to lose them because you went out there and you tried to work. Well, Social Security recognizes that. And as such, they have what's called a trial work period. In essence, let me give you an overview of what a trial work period is. Trial work period basically means that if you work or try to do any kind of work 9 months during a specified 5 year window, you won't have your disability benefits cut off. That's basically trial work period in a nutshell. Now, there's a whole lot of little funky provisions here and there. We're going to take a little bit of time talking about them, but I want to make sure that you're aware that's what the trial work period is. Now, I'm going to go down a few things, and hopefully this will make a little sense. If by some chance I'm not clear, please give me a comment, shoot me a message. I'll be more than happy to clarify. First of all, let's talk about what can be done. What type of work do they look at? Anything. Anything where you're making money. We're not talking about therapy or job work training or anything. If you go out and do work, any kind of work, I mean part time, on the weekends, anything, make money, that's deemed to be work or services for purposes of the trial work period. That's the first thing. Second of all, as you probably know, there's a variety of different Social Security programs. So you're probably asking yourself, okay, which programs are eligible for the trial work period? There's three of them. Disabled widow and widowers, that's where you're getting disability benefits based on the earnings of someone else. Disabled child, typically from a survivor standpoint, or disability insurance benefits. That's where you paid to the system, and as a result of you paying into the system, you're getting money based on your earnings from your disability. Now, let me tell you what you don't hear me say. SSI. SSI is a need-based program, so there's an income asset offset, meaning in an SSI sense, if you're working, they're going to reduce your money based on they reduce your disability, meaning SSI, based on what you're working with, the amount of work you're doing. That's why the SSI program is not eligible. So if you're a disabled widow or widowers, disabled child, or you are on disability insurance benefits, you qualify for this program. So those are the first things. First, we talked about type of work, which is basically anything that makes money, and then those programs, DIB, DWB, or and disabled child. So those are the first two things. Let's take a look at my notes here again. Please forgive me because I want to go ahead and move on to my next point. Ah, let's talk about those people who are not entitled to it. Meaning this, and this is where it gets a little tricky. If you've been found entitled to disability benefits, but excuse me, if you've been found disabled but not eligible for disability benefits, you don't qualify for this. If you are working at what we call substantial gainful activity level, meaning you're working and you're making a certain number of dollars, Social Security is not going to consider you for the program. Now, here is the other one that's tricky. Excuse me, SGA, we're talking about during that particular waiting period. And for those of you who are like, what's the waiting period? For disability insurance benefits, typically what happens is you give an onset date of disability. And then 5 months after that date is when your disability benefits typically start. So if you were found disabled on January 1, technically your benefits wouldn't start till June 1. If you're making money in terms of SGA level, substantial gainful activity, if you're working during that 5 month window, typically you're going to be viewed as not eligible for the program. Here's the other one that's tricky. Anything 12 months, any type of what we call substantial gainful activity which occurred 5 months, within a 12-month period from the date of your onset. Here's how that works. When you go apply for Social Security disability benefits, what's going to happen is you're going to tell them what date you indicated that your condition kept you from working as you would normally perform. So let's say I applied um, today, and I indicated my onset date is January 1st, 2010. Under the regulations, if I perform substantial gainful activity, let's say I go back to work and so forth like that, during the window of that 12-month window, so that would be from between January 1 of 2010, which is the day I say I became disabled, to December 31st, then I'm not eligible for the program. So just keep those things in mind. So those are people who are not eligible. Now, let's talk about when your trial work period begins and when it ends. Remember what I told you? It's 9 months within a 5-year window. The first month is the month at which you became entitled to benefits. The way that's typically interpreted is basically the day it was decided. So let's say, for instance, I applied in June of 2010. I got a favorable decision from a judge in December 1st, 2010. I indicated I became disabled January of 2010. And you're like, all those dates. Well, which date is important for you in terms of trial work period? The date the judge decided I was entitled to disability benefits. So on December 1, 2010, when the judge issued a decision that I'm disabled, that date starts your clock. Okay. Now, you want to know what's the 5-year window rule and so forth? 60 months from that date is what you need to look for. So that means anywhere between December 1 of 2010 and December 1, probably 10, 11, 11, 12, 12 to 13, 13, 14, 14, 15. So basically between December 1 of 2010 to December 1 of 2015, within that 5-year window, I can use 9 months, people. 9 months. And remember, not consecutive, meaning it's not 9 months in a row. It's just 9 months over that 5-year period. I can work and it won't count against me. That means if earnings appear on my earnings report, because Social Security gets them, it shouldn't count against me. Now, don't sleep, people, because I've told people this before, even those who participate in the trial work period. If you work in 2 months and you're making a bunch of money, Social Security is going to look at it. Don't let yourself be twisted. Don't get it twisted. If you're working 40 hours a week and making a nice sum of money, don't say, well, that's my trial work period. They're going to look to see, because if they believe that you are no longer disabled, you might be out of gas. But for our purposes, you got that 5-year window. What does that mean for you? You could try a couple of days here, a couple of days there, a couple of months here. So within that 5-year window, let's say I work a month in this year, in 2010, in 2011, 2 months in 2012, 3 months, whatever it is. I have 9 months by which I can work, and it doesn't count against me. And it means anything, whether it be part-time, half-time, whatever you want to call it. That is the trial work period. Now, let me add one other little caveat. There's also a thing called the extended trial work period. What the extended trial work period does is it gives you an additional 3 years, almost 3 years, anywhere from 15 months to 3 years, by which same rules apply, where if you're testing the workforce, Social Security may decide to take you off of your disability benefits, but you can get them reinstated. The difference between a trial work period and the extended trial work period, in the trial work period, you can work and they don't have to turn off your benefits. Extended, they can actually turn your benefits off. But if you want questions about that, we'll definitely hit that later. But just want to, well, actually, I think let me see if I can kind of jump on this a little bit now. Okay. Under the extended trial work period, basically you get an additional 9 months. Remember, you had 9 months for 5 years in that first trial work period? You get another 9 months for about a good 3-year window for the extended. Now, here's the kicker. When does it typically start? It typically starts the day after that trial work period ends. Usually one or two things happen. Like either the day after that 5 years or the day after that 9th month. So let's say you did 8 months next year, and then 8 months in 2011, and then you did 1 month in 2012. No, you don't get the window of starting the extended in 2015. You get the window from 2012, from that 9th month. When does it end? Well, it ends when either 1, your disability ends, or 2, 15 months after that, same thing, 15 months after your trial work period if you with regards to your disability, and then finally, again, if 36 months later, if during that work period of time and you haven't tried it and so forth, you've still got that extra window. So here's kind of a summation of it all for those of you who are thinking about trying this thing, and just keep it in this proper perspective. You got 9 months for 5 years after your date of entitlement, absent some weird situation. And if you have any questions, go to my blog at legalbeat.anthonyreeves.com, or just leave me a legalbeat.anthonyreeves.com, or just send me a comment and I'll go over this again. You get 9 months and 5 years after you've been determined to be found disabled. And then you get another 3 years and another 9 month opportunity within that 3 years to try working again. Trial work period, money doesn't count against you. Trial extended, money does in terms of turning off your disability benefits. However, if you decide that you can't do it, let's say that you work a month or two in that extended trial work period, but then after a couple months, you can't work, they can reinstate your benefits and you don't have to reapply. The best part about this, the extended, is that even though they turn it off, you don't have to reapply. They don't have to redetermine if you're disabled again. It just starts from scratch. I know I went over this really fast, but like I said, if you need me to address it again, please let me know. As always, this is brought to you proudly by the Reeves Law Firm, dedicated to representing the disabled and discriminated. www.reevesfirm.com.